Okay, thank you. Please be seated. And let the record reflect, I'll be moving to adjust my position where I can maintain visual contact. Attorney Durand, you ready to proceed?
Thanks, Ron. Just checking, Your Honor, you're all set?
Yes.
Ladies and gentlemen, this was not an accident. This was not defense of others. This wasn't done to prevent a kidnapping. It was murder. And he knows it. He knows. And that's why he's changed his story over time. He's taken time to craft what he's wanted to say. It's why he has changed what he told the police after he was caught to what he testified to on this stand. It's why he's tried to blame Caitlyn Naffziger for her death. The real victim here, the victim that you're here to decide this case about, is the unarmed woman who the defendant shot in the head, who was sitting on the couch with a child. Now, yesterday, when he testified towards the middle of his cross-examination, he told you in his own words, live from the witness stand, why he shot and killed Caitlyn. And he told you that in that moment, right before he got his gun, right before he pulled the trigger, that she hurt his daughter. His daughter. If you listen to defense counsel's opening, I lost track of the number of times that they described this child as his daughter. Caitlyn Naffziger, according to the defendant, hurt his child. She hurt her by holding her tight, hurt her by pulling her close, hurt her by pulling the child away when the defendant tried to grab her. Turning it on helps. Let's be clear. Caitlyn was holding their child, her child, as much as his. A child she carried for 9 months, a child she gave birth to, a child that she could hold and bear hug and be with just as much as he could. They had equal rights to these children, rights they had been arguing about since August of 2023. On the day that the defendant killed Caitlyn, he was angry. He was yelling. He didn't want to admit that during his testimony, right? I maybe yelled 1 to 2 sentences. The defendant needs to be in control. That is clear from his testimony. It is clear from his statement to the police. He is the person who operates best under stress. He needs to be the leader. He wants to have a plan, and you know what? Once a plan is made, there are no changes. Plans never change. But on that day, on February the 29th of 2024, the defendant was not in control of Caitlyn. You know, defense counsel stood in front of you and said, think about how he felt that he might have to lose his children, that he couldn't hug them when he was taken into custody. He was asking Caitlyn to drop her child, the youngest one off, their child, with him, to then see her daughter, their daughter, who she hadn't seen in a month and a half, sleep over and leave. Think about that day and what the defendant's behavior must have been. How his frustration over the situation, over the change in plan, turned to anger over the course of a day. It must have. It doesn't make sense that it wouldn't have. He didn't want Caitlyn there in his apartment. He wasn't happy that she had spent the night. It wasn't part of his plan. He wanted her to leave. He testified and told the police that during that day, on February the 29th, every 15 minutes or so, I think he said 15 to 30 on the stand, but he said 15 during his statement to police. Every 15 minutes for several hours, up to 5, he agreed with me yesterday, probably between noon and 5 p.m. He went to the room where Caitlyn was playing with their daughters, and he asked her when she was leaving. He hovered in the doorway. Her being there wasn't part of his plan. He wanted the girls with him, and he wanted Caitlyn gone. He told the police that. He told the police that he'd even discussed it with his mother. For at least 5 hours, every 15 to 30 minutes, he went to that doorway and he said, "When are you leaving?" He asked how she was leaving. When is her ride coming? And she was ignoring him. She wasn't ready to leave her children, their children, behind. The defendant was frustrated, but he became angry. He was angry because she wasn't doing what he wanted, wasn't following his plan. He was angry because she was ignoring his questions, because she didn't want to leave. He was angry because they were having the same dispute they'd been having since August of 2023. And Caitlyn, we know, apparently, didn't want to hand their 4-year-old daughter over to the defendant while he was yelling and angry, while he was pulling at the child and trying to yank her from Caitlyn's arms. Caitlyn knew how angry he was, and she knew that he was dangerous. She didn't know how much of a danger in that moment, but he'd show her. You know that Eloin told doctors at the hospital what happened. You know that she asked them to look at her ears because they hurt from the loud noise of the gunshot. Defense counsel wants you to believe that Dr. Robertson, somehow not knowing what happened, led Eloin to make the statement that she made. That simply doesn't make sense. You heard testimony from Dr. Robertson where she explained to you how she approaches a child. "Hi, I'm Dr. Natalie. Can you tell me what hurts?" That's not leading. That's not trying to get an answer from a child. It's trying to find out where they hurt and where to examine. And when Eloin was asked what hurt and where to examine, she said that mommy and daddy were fighting. She said that daddy hurt her and mommy, that mommy had lots of blood. Eloin didn't have any bumps or bruises from being held tight by her mother. She didn't say that mommy hurt her. She said daddy did. The defendant hurt them both, and he hurt them in the worst way possible. On February the 29th of 2024, Dustin Duren murdered Caitlyn Naffziger. He killed her as she sat on a couch in his living room. Remember the testimony. And ladies and gentlemen, you are the deciders of the facts, right? If defense counsel stands in front of you and they tell you something and you disagree with it, that's what you should do as jurors. You're the judges of the fact. If I stand in front of you and I say something that you don't agree was the evidence that you heard, that's what you should do. You should discard what I tell you and pay attention to the facts that you heard in testimony. But the facts that you heard was testimony from Dr. Weinberg, right? And he talked to you about close contact firing. And even under cross-examination, his testimony was that the defendant had to be 3 feet away or more from Caitlyn, and not just the defendant, right? But the tip of the gun. The tip of this gun had to be 3 feet or more away from Caitlyn's body, away from her head when it was fired. And so we know that the defendant stood at a distance when he shot her in the side of her head. When Dustin Duren fired a single bullet from this Beretta 9mm handgun, Caitlyn Naffziger was wrapped up on the sofa in their daughter's pink unicorn blanket. Her foot was on the coffee table. She had no shoes on, and there were none close by. She wasn't threatening anyone. She had no gun, no knife, no weapon of any kind, nothing. She wasn't even looking at the defendant. You know, defense counsel stood in front of you and said, well, if it happened the way the state described, well, then Caitlyn would have been shot in the head. Well, not if she wasn't a threat, not if she wasn't watching him, not if they weren't engaged in any kind of dispute or argument like the defendant has said. We know from the evidence that she was shot here in her temple. That's what the doctor can tell you. In terms of positioning, that's based on how they were interacting at the time, and Caitlyn wasn't looking at Dustin Duren. The defendant's bullet entered the left side of her head at her temple. It traveled straight through her brain. When the bullet exited on the right side of her head, it took pieces of her skull with it. The bullet continued in a straight line, cutting into the built-in bookcase behind her, ricocheting through the drawers. You know, Caitlyn was likely dead before Eloin even saw the blood, before Eloin began screaming about the noise of the gunshot hurting her ears. The defendant didn't check to see if Caitlyn was alive, to see if she could be saved. Instead, he ran. He loaded his car with changes of clothes. More than you needed for one night, more than you need for two. He put his desktop computer tower in the trunk. He turned out the lights. He turned the key in the deadbolt and locked the door. He drove south. He went dark. You know, defense counsel made it a point that you didn't need to know about his phone searches or his phone records. You know what they told you, those records? They told you when he left his house, which gives you an idea of when he killed Caitlyn. Those records that you have in evidence show you that around 6 o'clock, between 5:30 p.m. and 6 p.m., on the 29th of February, the defendant began to leave his home. Caitlyn was dead, and he was on the run. A person who's justified, who acted lawfully, who acted to defend someone, they do not run. They stay in place. They do the right thing. They ended the threat. They call the police and they tell them what has just happened. It's the first thing that they say. They yell it at the top of their lungs. They scream that they had no other choice. But the defendant didn't do that, and he didn't do that because he had choices. There were options that didn't involve putting a bullet through an unarmed woman's head. He knew then that what he had done was not justified. It wasn't in defense of someone else, and it wasn't to stop a kidnapping. It was a murder, and he acted like a murderer. You know, a murderer packs their clothes and drives through the night with two little girls after he has killed their mom and left that mom dead in his living room. A murderer turns off his phone so the police can't find him. A murderer needs 16 hours to tell the police that something happened. And that's how long Dustin Duren had. From 6 p.m. or 5:30 p.m. when he left that house until he was taken into custody at 10:30 the next morning, he had 16 hours. But you know what's even more is a murderer needs 3 hours of background testimony at a trial before he can tell his new version of what happened. A murderer needs a year and a half to explain that his actions were an act of defense of others. You know, ladies and gentlemen of the jury, the defendant thinks in this case that he can fool you, that he can put this claim of defense of others in front of you, and that you will jump on it and detract from his actual actions and his intent. When you were chosen as jurors in this case, each of you individually, you brought your life experience with you. You brought your ability to make assessments and to make judgments, and you brought your common sense. You know, we keep a lot of things that you're not allowed to bring with you into the courthouse or bring with you into the jury deliberation room, but your common sense isn't one of those things. Your common sense and your knowledge about people, it stays with you when you come in the courthouse. It stays with you here in this courtroom, and it will sit with you as you go into that back room to deliberate. Your common sense and your experiences is why you were selected. And it gives you a framework and a basis to evaluate what happened on February the 29th of 2024. This is a framework that you can use to evaluate the witnesses, the testimony, and the evidence. Your common sense plus that evidence and plus the court's instructions are the tools that you have. They're the only ones we give you, but they're the tools that you have to fairly and impartially weigh the evidence in order to determine whether the state has proven beyond a reasonable doubt in this case that the defendant killed Caitlyn Naffziger, and that when he did that, he was not acting in lawful defense of others to prevent a kidnapping when he shot her in the head. You, as I've explained, are also the judges of fact, and that is why you use your common sense to evaluate that testimony. You give the testimony of each witness what you believe it deserves, not what the state tells you and not what the defense tells you. In terms of the first part of your job, determining whether the state has proven beyond a reasonable doubt that the defendant killed Caitlyn Naffziger, at the beginning of this case, we stood in front of you, my colleague, and told you that this is not and would not be a complicated finding for you. This isn't a whodunit, that by the conclusion of the evidence here, you would know beyond a reasonable doubt that the defendant is the person who shot and killed Caitlyn Naffziger. Throughout the past week, you have learned that he confessed to his parents, he confessed to the police, his gun is the murder weapon, that he knows that when you point a gun at a person, you intend on killing, that he knows exactly where the bullet went, and that he has testified now in this case that he is the one who fired the shot. You know beyond a reasonable doubt that he killed Caitlyn Naffziger. The defendant is facing several charges related to this case. Those charges include second-degree murder, reckless conduct with a deadly weapon, and endangering the welfare of a child. The judge has explained some of the law to you, and shortly he's going to explain to you what it means to commit second-degree murder. The defendant, to be clear, is charged with two variations of second-degree murder. He's charged with knowing second-degree murder and reckless second-degree murder. The difference is in what he was thinking at the time that it happened. The court will talk to you about those charges of reckless conduct and endangering the welfare of a child, and those charges, so that you understand, are related specifically to the defendant's actions in which he placed 4-year-old Eloin in danger or violated a duty of care that he had to her. The facts of this case as presented to you over the past week and a half, have demonstrated that each of the requirements that you need to find the defendant guilty of these crimes beyond a reasonable doubt have been met. Let's demonstrate what I'm asking, or what the state, what everyone's asking you to do here. I want to look at the factors of second-degree murder. Up on the screen you have in front of you part of what the judge will instruct you on. The judge is the judge of the law, just like you are the judges of the fact. So his instructions will hold, okay? Now you have to decide whether the defendant caused Caitlyn Naffziger's death. Again, this has been proven. The defendant admits that he was the person who pulled the trigger, that he shot Caitlyn in the head, he caused her death. For knowing second-degree murder, you also have to consider whether the defendant acted with a knowing intent to cause her death. That means that when he fired the gun, he was aware that such conduct would cause Caitlyn's death. You should consider all of the evidence that you've heard throughout this case when you decide whether the defendant knew that he would cause Caitlyn's death by shooting her that day. You've heard about the defendant's ability with a gun, his military training. He testified that he raised the gun, and he admitted that the purpose of pointing a gun at someone is to kill. There is no other purpose. He knew that this would be the result when he pointed his gun at Caitlyn and when he pulled the trigger. He knew exactly where the shot would go and the damage that it would cause. For each of the charges that we're talking about, you must also consider the defendant's claim that he was acting in defense of others. Specifically, the judge will instruct you that in this case, acting in defense of others means that the defendant had to not just reasonably believe. Now, defense talked to you in their closing about reasonable. It was a reasonable belief, a reasonable belief. But you'll note that on the screen, and as the judge will advise you later, that there's actually another portion of that. The defendant's belief has to be an actual belief and a reasonable belief. We expect and anticipate that, the defendant testified from the witness stand that all he had about this kidnapping plan or kidnapping idea were his suspicions. Suspicions are not an actual belief, they're just suspicions. The defendant didn't have an actual belief here, and he didn't have a reasonable belief here. And if he didn't have those two things, if his belief wasn't actual, if his belief wasn't reasonable, then he was not lawfully acting in self-defense, and his murder of Caitlyn is not justified. There was a lot of discussion about where Eloin, where the 4-year-old is at the time that the defendant fired. And that's one of the things that you can consider, both in the charges of reckless conduct and with respect to the defendant's claims. At the time that the defendant had fired, if we look specifically at his claim that Caitlyn was kidnapping, right? At the time that the defendant had fired, he had grabbed Eloin with his left hand, and he shot Caitlyn with his right. With that action, the defendant ended any argument he might have made that he had shot Caitlyn to prevent a kidnapping. It was over, it was done, and he had the child. But it's the state's position that there was never any kidnapping. Caitlyn was never about to commit a kidnapping. She was not about to do anything. She had made her position clear to him. She was refusing to leave, and she was seated on the couch holding their daughter. In the defense's opening statement, they told you that the defendant pulled Eloin to safety before he fired. He told the police in his statement that he had grabbed her, pulled her back, and then shot. But yesterday in his testimony, he stated that he had just pulled her forward by her shirt and held her in place. He implies that she was still on Caitlyn's lap when he fires the gun. But the defendant's testimony doesn't fit with the evidence. Dr. Weinberg testified that he found no evidence that the shot occurred within close range. He testified even on cross-examination that his opinion was that it had to be 3 feet or more away. He found no evidence of stippling. Now, this isn't gunshot residue, it's stippling. Little burns of gunshot powder embedded into Caitlyn's skin or face. She didn't have any. There was no stippling on Caitlyn's wound. There was no stippling on her face, her neck, or anywhere on her. Dr. Weinberg found no evidence of soot deposits on her face, and he testified to you that based on his examination of her body, the muzzle of the gun had to be at least 3 feet or more, not closer, 3 feet or further back when it was fired. And if the shot came from 3 feet or more from Caitlyn's body, there is no possibility that Eloin is on Caitlyn's lap when the defendant fires. Eloin was in his arms. Even if the defendant had fired the gun in the way that he demonstrated or tried to demonstrate from the witness stand yesterday, he would have been closer to Caitlyn than 3 feet. The gun would have been closer still. Just as he told the police, the defendant grabbed Eloin and pulled her back. The defendant then had to step back to shoot Caitlyn Naffziger from the distance that her body shows the shooting happened from. Now, I want to talk to you a little bit about defense counsel's desperate efforts with respect to State's Exhibit 24A to talk about a hair on the slide. No one knows whose hair this is. No one. Defense counsel does not have to put on a case. They do not have to bring up evidence. But if this hair was the linchpin that solved it, they had every right and could have. And they chose to put on a case.
Objection, burden shifting.
Members of the jury, I'm going to strike the last sentence from the state's argument. And, 2 other comments. The defendant had no burden to test any evidence in this case. And in fact, the defendant has no burden to produce any evidence in this matter. So with those instructions, I'll allow the state to continue.
Thank you, Your Honor. Ladies and gentlemen of the jury, defense counsel kept showing you this photograph, the word hair, because there was a hair in the slide. And they want you to somehow put together and believe that that is Caitlyn's hair, because that would somehow show you and prove by their theory that the defendant was closer than 3 feet. That you should use the fact that there's a hair on the gun, a gun that was next to the defendant, next to his child, in a pocket inside of a door in a car, and that you should somehow use this missing hair that hasn't been tested to decide that that means he was closer. That you should use this hair to disregard the testimony, the evidence, and the expert opinion of Dr. Weinberg. That doesn't do this. There's no inference as to whose hair. You know, I think we all understand, especially possibly the women on the jury, that hair falls out. It's everywhere. Hair on a gun isn't an inference that you can make. It doesn't matter whose hair it was. None of it would show that Dr. Weinberg's testimony is called into question. Dr. Weinberg, who testifies that this gun, the muzzle of it, the very tip, was at least 3 feet away from Caitlyn when it was fired. 3 feet from here to Caitlyn. You can make reasonable inferences from evidence. You cannot make jumps or wild conclusions. You have State's Exhibit 26B in evidence. That's the defendant's statement. This is an image from that, just showing you him in that room where he was interviewed, in that room with police officers on March the 1st of 2024. He didn't claim during this interview anywhere, at any time, that he acted to defend somebody, that he acted to protect Eloin from being kidnapped. The defendant didn't shout it at the top of his lungs. He never once said he acted in defense of anyone. Unlike in his prepared testimony Friday of last week and yesterday, the defendant didn't tell the police that Caitlyn was kidnapping anyone or about to kidnap anyone. He also didn't tell the police about his suspicions or make hypothetical statements that someone might be outside of his apartment. He didn't tell the police that she was demanding that he pay her money in that moment. He talked a lot about times she'd asked for money in August of 2023, in September, October, leading up to this incident, but he never said those demands happened before he shot her. He didn't tell the police that she was demanding that he sell his car and give her money. He didn't tell the police that before he shot her in those moments, that he'd never see the kids again. These are all statements that he added over a year and a half later in support of his defense to excuse his murder of Caitlyn. You remember when he was specifically asked in that statement if Caitlyn was threatening anyone or causing any harm, he said no. He never once said he had to act to defend anyone. He never once mentioned a kidnapping. Not until yesterday in this courtroom did he make that statement. And even then, if you remember his testimony, he didn't say that he acted to shoot because his daughter was being kidnapped. He stated that he had shot and killed Caitlyn because in that moment, she was hurting Eloin. You know, the defense has argued to you that Brenda Plamondon and Caitlyn Naffziger formed some kind of secret plan to take the children. Their plan involved code words and planned 911 calls. And it never happened because Caitlyn never called. You know, for a plan to be secret, the people involved in it don't tend to broadcast what they're about to do, don't tend to stand in front of the person they're about to steal a child from and say, I'm going to call the police, I'm going to take the kids. You know, about that plan, what defense has termed as a secret plan to go along with the broken promises because Caitlyn wasn't following the defendant's plans. The word plan comes up a lot, and I apologize because it's hard to keep them all straight sometimes. But Caitlyn never called Brenda. She never texted her. She never asked for help. She never sent a code word, and Brenda never called 911. More important to your consideration, defense counsel advised you're not to Monday morning quarterback the defendant's choices, right? You're only to consider what he knew in that moment. And so if he didn't know that Brenda and Caitlyn had talked about this code word and 911 call plan, then he didn't consider it in the moments before he shot. What you do know is that the defendant didn't know about it and that it never actually happened. And because of those things, because he didn't know, you cannot use it to make the defendant's now stated belief that the defendant was going to kidnap the children become an actual belief or a reasonable belief. You know from his testimony that he only had suspicions. He didn't act on an actual belief, and his belief and his actions were not reasonable. On March the 1st of 2024, 16 hours after he had murdered Caitlyn, the defendant drove from Vermont into Keene. He told you that he was on his way to turn himself into police, to turn himself in for shooting and killing Caitlyn. He drove past multiple police stations in multiple states. He drove past the New Hampshire State Police Barracks at Troop C. He wanted to be arrested on his own terms. He knew that he would be taken into custody. He knew there would be an investigation, and he was ready for that. That's why he came back. He knew that speaking to the police was his opportunity to provide a statement about what had happened, his statement, and he wanted that opportunity. He wanted to speak with police and tell them why he shouldn't be in trouble for what he had done. But he didn't turn himself in. He got taken into custody at gunpoint in front of those two little girls whose mom he had killed. He had 16 hours to think about and prepare for this moment. He had 16 hours to determine what to say, what exactly to say and how to say it. He'd given himself the time and the space to put any spin that he wanted on the events that occurred in his living room. He'd had time to consider what it was he was going to tell police, how he would portray himself, how he would portray Caitlyn. Besides his 4-year-old daughter, there was no one to contradict him. And so he waived his Miranda rights. He spoke with investigators for over 2 hours. They let him talk about anything he wanted to address and just asked him questions to fill in the blanks. This was the defendant's opportunity to tell them why he had killed Caitlyn. He said she refused to leave. He said she was bear-hugging their daughter, that she wouldn't let go, that he tried to pull the child away. If you listen in the tape, there's about 40 minutes where he talks about their background and his disputes with her and their custody issues. It's not until almost an hour in that he actually starts talking about the moment that Caitlyn was in his apartment and leading up to his killing of her. In those moments, at around, I believe it's 1 hour and 4 minutes, the defendant says he was trying to grab Eloin and be like, hey, let go of Eloin. And she just wouldn't do it. And that was kind of the tick. And then he says, I think the moment was definitely very deliberate and fast. It was like the line had been crossed. That her not letting go, her continuing to hold Eloin, was the only thing, the tick, the moment in his mind when he decided to kill, the moment when he decided to walk for his gun. And you know that he decided to kill in that moment because he did grab his gun. He racked the slide. He switched the safety off, and he walked over to shoot Caitlyn. And you know that Caitlyn saw him as he picked up that gun, because he told you in his testimony, she was closer to it than he was. And you know because you heard that gun as it racked when Jill Terrio was showing it to you. You know Caitlyn heard the racking of that slide. And for what the defendant would admit to in his testimony yesterday, she at least tried to ask him what he was going to do with it. But he didn't answer, because within seconds, he had shot her in the head, and Caitlyn was dead on the sofa. The defendant shot and killed her without a second thought, and he never, not one time, said anything about Caitlyn being a threat or a danger to anyone in that moment, not until he took the stand yesterday. Compare that to his actions as he described them in that story about the burglar in Nevada, a story that defense puts to you in their closing as explaining why he didn't call the police when Caitlyn was in his house. But it does so much more than that. It shows you the difference in behavior that the defendant has, the restraint that he can show, the fact that his muscle memory isn't all that's to him. A stranger trying to break into his home received more consideration than the mother of his children. That stranger was told to leave. He told them to go. He called the police. The defendant warned the stranger that he was armed with a gun. He went to the length to open the door and show the stranger the gun. He sat and waited with his loaded gun while the stranger tried the door, tried the windows, tried to break in. His muscle memory didn't take over. He didn't just shoot. The defendant never fired. He didn't shoot. The stranger walked away unharmed. But the mother of his children, she had to die. You listened to his statement during the presentation of the case. You have it in evidence, and you can listen to it again as many times as you want. You'll have a laptop back there that hopefully has a working CD player. You can listen to it, you can rewind it, you can jump to spots you want to hear. You should watch it. You should compare it to the statements that the defendant has now given to you from the witness stand. When you watch it, watch his demeanor, his body language, his facial expressions. Listen to the places where he hesitates or doesn't really answer the question that he's asked. Listen to the places where he scoffs, laughs, or smiles as he provides information to the police about where the bullet struck the mother of his children. Listen to the information he gave the police and his reactions and behavior when this was still fresh in his mind 16 hours later, when he hadn't reviewed any evidence against him, but instead was telling things as they had happened. Even then, much like the defendant spent 3 hours sitting on this witness stand talking about child custody and his life before children, as well as his love of his children, the defendant spent the first 40 minutes of that interview talking about those same things. Again, the defendant begins discussing the shooting about 40 minutes in and the reasoning for it about an hour in. He says that she was holding Eloin and refusing to leave. That's it, nothing else. Nowhere in the statement does he say that he acted because Caitlyn was using force to commit any crime, let alone a kidnapping or being about to commit a kidnapping. Nowhere in that statement does he say she was harming anyone or physically threatening anyone. Many of the statements that he made yesterday are not in the statement to police. He never told the police that that night Caitlyn again demanded money from him or to sell his car. He never told the police that he was concerned that Caitlyn could reach for a gun. He never told the police that Caitlyn put her foot on the table and tried to use that to push away from him. He never told the police that Eloin shrieked or yelled or cried out because she was being hurt. He never told the police that he taught Caitlyn to fire that gun. You know, the defendant told you that during his testimony that he wanted you to believe that he's adding this information because he was misunderstood. He wasn't misunderstood. His words weren't misinterpreted. He just never said these things. Not for a year and a half. He is adding these things to change your opinion of him and of his actions, to try to get away with murder. The defendant spoke with detectives about every bad thing he believes that Caitlyn Naffziger had ever done to him or concerning their children. Is there any doubt in your minds that if she had said all these things he added from the witness stand, that he wouldn't have included them for the police? He'd had 16 hours to figure out to portray her as the villain and himself as the victim. The defendant has testified about being a Marine and being a father. Both of these things are true. But a third thing is true. He murdered Caitlyn Naffziger. He killed her out of anger, anger that she was questioning his plans, anger that she was remaining in his house and wasn't leaving like his plan said she would. You got to hear those 3 hours of testimony in which the defendant spoke about his history and his love of his children. You'll never hear Caitlyn Naffziger's history or about her love of being a mom, about her love for those same children, children she carried to term, her memories of their first years. You won't hear about Eloin's first Christmas when she was just 2 weeks old. All you got to hear was when Brenda Plamondon told you that Caitlyn was so loving and so happy to be a mom. You don't get to hear Caitlyn's story about those last moments of her life. She isn't here because the defendant killed her. The defendant killed her out of anger. He killed her because he wasn't going to lose power over her, he couldn't control her, and he wasn't going to swallow his pride again. The defendant is bigger and stronger and heavier than Caitlyn Naffziger. He talked with detectives about whether she'd ever been violent with him, and he told them he would never have registered it because she was so tiny. She couldn't hurt him if she tried. Not then, not ever. And one thing the defendant never said, not once, not during any statements with the police and not from the witness stand, is that Caitlyn never, ever hurt their children. There's no evidence that he even would try to say that. Now, the defendant wants you to believe that he shot this small, unarmed woman in defense of others, that this murder was justified, that he had no choice, that his use of force was somehow proportional, because the judge will explain to you that his use of force has to be proportionate to what he is responding to. The defendant wants you to believe that what he did was reasonable. He wants you to find that Caitlyn was committing or about to commit a kidnapping when he killed her, that she posed a danger when he killed her, and that this makes his killing valid, that he was right to shoot her in the head. All of this despite his clear testimony that he had shot and killed her just because she had hurt their child in the moment before the shot rang out. In order for you to find the defendant not guilty in this case, you would have to find that he acted in defense of others, that he both actually and reasonably believed that the mother of his children was committing a kidnapping or attempting to commit a kidnapping in that moment. Again, the defendant himself testified that he had suspicions, but you cannot kill someone over suspicions. It's not an actual belief, and it is not reasonable. The defendant testified that Caitlyn was threatening to call the police, that she threatened to take the children, but you cannot kill someone over a threat. That is not reasonable and is not an actual belief. There is nothing in the defendant's statements to police or even his testimony that demonstrates that deadly force was necessary or proportionate to the reason that he said he fired. He was a Marine. He was trained in martial arts. She was unarmed. The defendant didn't use deadly force because he had no other choice. He shot an unarmed woman in the head. He murdered Caitlyn. You have an evidence, States Exhibit 9A. So just blown up for the purpose of presentation. States Exhibit 9A shows you Caitlyn as the defendant left her in that living room. This is a photograph of a mother sitting snuggled under blankets on a sofa, who has one foot kicked up on a coffee table, who has no shoes, no weapons, and poses no danger. This is a woman who moments earlier had a child on her lap, their child, their child. This is not a woman who was committing or about to commit a kidnapping when she was shot in the head. This is a woman with no friends in Berlin, New Hampshire, no friends in the area. Her family, a 2.5-hour drive away. She had never been there before. She had no car, no bus ticket, no means to leave. The defendant's reasons for shooting Caitlyn had nothing to do with the kidnapping. He told you he shot and killed her because he believed that Eloin was being hurt. He described that Eloin was hurt during his efforts to take her from Caitlyn. He said Caitlyn hurt her by holding her too forcefully. A person cannot use deadly force to protect someone from being held too tightly by their mother. That's not reasonable. The defendant did not have an actual or reasonable belief that Caitlyn was kidnapping or about to kidnap these children. There's no justification, no excuse. This is not a reasonable use of deadly force. The facts tell you that. The law tells you that. Your common sense tells you that. The defendant shot this unarmed woman in the head while she was sitting on a couch, wrapped in a pink unicorn blanket. He shot her because she refused to leave and was holding their daughter. This wasn't an accident. It wasn't self-defense. It wasn't to prevent a kidnapping. It was murder, and he knows it. And now, so do you. The time for excuses is over. Please find him guilty of all of these charges.
Okay, members of the jury, we're at the point where I am now going to provide my instructions to you. Once again, I do think under the circumstances of this case, I do think it's appropriate to take a brief break before I provide you with my instructions. So we'll be back at 11:35. You'll hear my instructions. After that, you will be ready to deliberate. And until then, again, until you have my instructions, I instruct you not to discuss the case with anyone amongst yourselves. And if anyone does so, please report that to a bailiff. As soon as we're back, I'll complete my instructions to you. And at that point, you can deliberate. Thank you. Please rise for your all rise.